All right, welcome to our virtual Justice on the Block Legal Informational Clinic. This clinic is part of the virtual series Barriers to Disaster Recovery. To help us learn more about title clearing, we are here with Giovanni Bush, Disaster Response Attorney in the Tallahassee office, and Ryan Phillips, Disaster Response Attorney in the Panama City office. Take it away, guys.
Hey guys. Greetings. I know disaster response work is very interesting, but I bet title clearing was probably on everybody's top list of informational things they wanted to hear about tonight. So thank you for the time and for the platform to be able to share with you guys.
All right. You want me to take the lead, Gio, and ask you a few questions?
Yeah, let's get the ball rolling.
All right. So I think we're talking today about barriers to disaster recovery. And so, and when it comes to clear title, what can you tell us about, or what are we looking at when we're talking about barriers to disaster recovery when it comes to clear title?
No, absolutely, Ryan. I think it's key to think of clear title as one of the golden tickets to disaster recovery and preparedness. So if you look on our website, you'll see a lot of helpful webinar series about ways to prepare yourself pre-disaster. We spend a lot of times talking about some of the ways you can legally prepare with both the documentation that you have, things to keep in mind regarding the types of claims or benefits you might be entitled to legally. But when we talk about clear title, we're really trying to deal with what types of benefits you might be entitled to in the wake of a disaster that have to deal with home ownership. And so clear title is super important in that, because believe it or not, without a clear title, you cannot sell your home, cannot insure a home. It's often difficult to even enter into financing agreements, which we see a lot for our clients. And so when a disaster hits, we see a lot of our clients, unfortunately, are caught in the middle of trying to figure out how to file claims without being able legally entitled to do so. On top of that, too, we think of FEMA as one of the best resources to provide aid. And FEMA and a lot of our state agencies do step in once a disaster is declared, or a hurricane is declared as a federal disaster. And those are important, and they can help provide even repairs to your home. But unfortunately, without clear title, a lot of times individuals will not be able to request or receive any direct forms of resources available from FEMA directly to their claims. And so we see this even now. I want to remind you guys first and foremost that when you have a disaster that's been hit, and if you've been impacted by a hurricane, what happens is then once you live in a county that's been declared as part of a federal disaster, you can quickly go to FEMA and register for assistance either online or through their app or call their number. And so FEMA has gone through great strides to make it more accessible to be able to have individuals seek those resources. But what we see often more often than not at legal services is that individuals aren't aware maybe of who their home is titled in, because it might be property that has gone on in the family through heirs and heirs over generations, or they just don't have their paperwork or information available to them. And so they're not really aware of what they can do. So this is tough because with FEMA claims in particular, there's often a deadline set for when the application deadline comes to seek that recovery. So as soon as the disaster is declared as a federal emergency, that starts the clock a lot of times. And so that's why we want to make sure that all of you in the community are aware of the need to make sure to have some of those title documents prepared beforehand, so that way you're not caught off guard. And that's why we want to take this time with you to talk about how important it is to make sure the title in your home is clear and clearly list you and the other individuals in your home that you wish to confer title to accurately and legally. So that's why we're taking our time today.
And would you agree that it's certainly not a foolproof method to try to fix the circumstances after the fact when you have a FEMA application pending, when it comes to the deadlines and things like that? People can completely miss out on recovery entirely if they're not able to correct those issues very quickly.
Yeah, no, Ryan, that's a good point, right? Like when in doubt, file it out, get that claim out there and try to see what you could do to make sure you don't lose any of the resources you might be entitled to. But our hope today is by trying to give you these nuggets of wisdom, we can try to get you prepped for what you might be able to do before such an incident occurs too. But you're absolutely right. Don't lose out.
Well, what about outside of disaster recovery? Are there any advantages to having clear title to your home?
Yeah, no, absolutely. See, on the most fundamental level, with clear title, it gives you control over the property. And so that's one thing right now, especially, as we're in the wake of a pandemic too. And you have everything from the property values are increasing in different measures. And so we have a lot of clients who have reached out who want to sell their home, right? Or looking to see if they can be able to leverage their home into some sort of financial agreement for them. It's very important to have clear title for that. If your name is not on the title, then unfortunately it can be difficult to obtain either insurance or some of those renters agreements too. Even beyond that though, just being able to utilize the title for property ownership rights. One thing that to realize under Florida law, the Florida Constitution, is you have qualified individuals can apply for homestead exemptions, both on their taxes, and it provides also greater protections against creditors under that homestead exemption as well, too. So that does require you to be able to obtain clear title to be able to seek some of those exemptions, too. And also your ability to receive financial assistance, too. So we talked about with FEMA claims. One of the most simplest reasons too is if you're seeking to repair something in a home too, and it can become overcomplicated. And what we see more often than not is after disaster recovery where repairs have been made to a home and there's just all types of confusion over who owns the home and who is entitled then to come after any faulty repairs or faulty work done. It's just helpful to be able to have that title documentation available and to make sure that title has been cleared. So sometimes we see individuals who have to wait a long time when they're filing their claims for repairs or seeking assistance in the community. For instance, Florida had launched back in the summer, up to the summer of 2021, its Rebuild Florida campaign to provide repairs after Hurricane Michael. And unfortunately, for a lot of clients, there's a short window of time to apply, and it required individuals to have clear title to their homes or in mobile homes in order to receive repairs. And so it was a lot of times too, it's important to note that, like Ryan said before, for some of these clients, even still, we were able to at least get an application out in time and be able to work with the Rebuild program and the Department of Economic Opportunity to try to keep some of these claims going. And so if that is you, there are ways to kind of reach out to DEO and try to figure that out. But on the other end, it kind of reminded us of the importance of making sure to have title work done to try to expedite those repairs to the home.
Right. So that's important. And that's why we're talking about this today, right? Because we have even some people who have really participated all that they could with their Rebuild Florida application. And some of those clients are unfortunately going to miss out on funding because eventually funding runs out and they have to prioritize their applications. And I think the one of the goals today is to try to emphasize to our potential clients that there's a need for to be proactive and that FEMA or Rebuild Florida or whatever institution it may not be able to save you if you do not have all your ducks in a row.
Yeah, no, that's right, Ryan. And that's good. I think beyond stressing just the importance of this, because there is going to be a matter of saying, well, I've lived in the home for this long. I haven't had the need to go through some sort of process to clear the title. I think everyone in my family knows I live here, right? But I think what we're hoping to do is be able to point to the interest of saying, well, it's time to kind of take those initiatives so you can protect yourself legally, right? And so Ryan, if someone is interested in the community of kind of going through this process, could you give me a breakdown on what that process is for clearing title, mainly through probate proceedings?
Sure. When an owner of property dies, is my video not on?
Oh, there you are. Yeah.
Sorry about that. When an owner of a property dies, you typically have to instigate a legal proceeding called probate. It can be very complicated with large estates. It can be very simplified. I've had probates that we filed and cleared within actually 4 weeks. I think is my record. That's pretty quick. And we have judges that, at least in Bay County, that move quick as long as you have everything lined up. When it comes to ownership, there's multiple scenarios where you may need to do this. I'm just going to go through a few right now. I was jotting down a few notes. The family member has died and you're supposed to inherit the property, but you're not on the title. That's typically going to be a probate case to get you to full ownership. You co-own the property with another person who has died, same deal. Sometimes you can have an attorney check the deed, and if you're the co-owner, there may be a right of survivorship where you may be able to avoid probate. But if not, it depends on the size of the estate, but some of these proceedings are fairly quick, and legally it's a huge difference when it comes to disaster recovery, insurance coverage. If you needed a mortgage, homestead exemption is another issue that, if you've been denied a homestead exemption because there's some sort of problem with the title, you would need to look at the deed, and you might even have to probate a former owner's case or estate, or current owner technically is what you would call it, because and you even have sometimes where you have the property appraiser's office will acknowledge that a person is the current owner, maybe because they're paying taxes on it, something like that. That doesn't necessarily mean that they have clear title. And so if they were to try to get disaster assistance or insurance coverage on the home, they may have problems, even though the property appraiser lists them as the current owner, and they've lived there. Maybe they've lived there for 10 years. And so I guess back to the issue, probate is typically going to be the remedy for those types of situations.
No, that's great. That's great. And so opening up probate proceedings, and normally that's you going through the clerk of court or through a local either legal aid foundation if you're entitled, or in any of our counties, and you meet the credentials for that, seeking free and available legal services to you, or reaching out to an attorney that you know in the community, or one that you might have. But it's seeking to open probate proceedings. Can you kind of give me a breakdown though? What does that court do, right? Let's say someone goes there, they're going to file a probate. What exactly is going to happen?
Yeah, I would say, just to add on to your last note, our office does handle probates. We handle quite a few every month. So if you're in any county within our threshold, I'm in Bay County, but you could be in Holmes, Washington. For me, Holmes, Washington, Bay, Gulf. And we typically handle those for the client. So as long as they take the initiative to call us and they fill out the forms, questionnaire, let us know who the heirs are and the property and liabilities and things of that nature, we can file it. The probate court, essentially the judge goes through the property of the deceased, the liabilities of the deceased. He determines who the beneficiaries are. and he distributes the property. Now, a will may govern that, or if there's no will, then Florida law governs that, and it dictates everything. If there's a stepmother and your father passed away and you have a stepmother, and you want to know what your potential distribution would be if there's no will, Florida law dictates that, and the judge simply follows that law if there's not a will. If there's a will, he makes sure there's an effort to determine that the will is valid, and once that's determined, it's admitted, and all the properties distributed per the will. A lot of what we see is clients without deceased folks without a will, and we have to determine, who the stepchildren are and who all the beneficiaries are, file all that, and then the judge will determine how to proceed, which parties obtain which property, and he will enter order to that effect, and then that order is binding, just as if it was a deed from the person who's deceased.
That's right. And so specifically with a property that's titled and the deceased individual's name, and if someone is seeking to have their name on the title, and either through Florida law, they might be entitled to it, or through the will itself, then it's going to be that order from the judge, an order from the judge that will then have the property title in their name, right?
Correct. And without that, you're stuck in the scenarios that we were discussing to begin with.
That's right. That's right.
But I will say, just to, it can be very, very quick. I don't want folks to believe that this is a super complicated process. It can be if you have a large amount of assets, but if you have a pretty simple estate, we can typically get it through probate within a few months. Now, if there are beneficiaries that are debating about who should own the property and there's no will, there might be more to it. It may take more time, but it's really a simplified procedure for most of the clients that qualify for our services, and they can have title within their name, some in best case scenario within a month. Yeah, which is great.
Well, that's true. Absolutely. Even in the midst of the pandemic, with the courts having a lot of cases and things being distanced, really our Florida courts in a lot of our counties have done a good job of trying to keep cases moving too. And so
I agree with that.
Yeah.
Yes.
Yeah. And would you say to Ryan, then besides, I know we've been talking generally about probate, right? We're using this word to talk about these type of cases to make sure that the deceased's property will be distributed properly. But when we say probate, there's different types of probates. And so it's kind of in straightforward terms, could you maybe explain what they are, just very simply, so that way we get an idea of what type of probate someone might need to seek out?
Sure. There's a handful. I would say the two most common are a formal administration and a summary administration. With a summary administration, if the deceased has been deceased for over 2 years, or alternatively, if their assets are in total less than $75,000, then they would qualify for summary administration. The assets less than $75,000, that would exclude any exempt assets, which would include a homestead. So a lot of folks, they're probating a simple estate, couple $100 in a bank account, a homestead property, and maybe a vehicle. Vehicles, we'll talk about exemptions in a minute, but you have exempt property that would not factor into the $75,000 asset calculation. If you're less than that, you can have a summary administration. And I'm guessing your next question is, what's the benefit of a summary administration?
Yeah, versus a formal. What does one dress up nicer and one
There's
is casual?
Quite a few. One would be that there's no personal representative, and a formal administration is a personal representative that has to be appointed. There's sometimes there's not an agreement. Nobody really wants to serve in that capacity. They just want the property distributed the way it's supposed to be distributed. And with a formal administration, you have to have a personal representative, and they also collect a fee. And I would say with a summary administration, you also have any beneficiary or personal representative can submit the estate to the summary probate process. There's no obligation to notify unknown creditors. There is an obligation to notify known creditors. So if you're aware of a mortgage, well, really, if there's a mortgage, you have to become aware. It's reasonably something that you should be able to determine. And you will be required to serve those creditors formally.
That's right.
Of the petition for administration. And then they would have a chance to file a claim. Now, if the only property is exempt property, then there's not much they can file a claim against. But you still have to formally notice them. In a formal administration, you have to do that with all creditors, and you have to give them a 3-month period to file claims. So then you're talking about speed of completion. You're really slowed down by the fact that you have to wait on who knows who may be out there, who's a creditor of my dad or my grandfather. And with a summary administration, you don't have to do that. You have to make an effort to find out, reasonably ascertainable facts or debts. Does this vehicle have a lien on it? Does this home have a mortgage? Those are pretty simplified things that you'll have to go through. But it's not on the same level as a formal administration. And that's why I'm saying some of our cases that we regularly deal with, you can have the estate probated fairly quickly because you're not in that scenario. It's also less expensive. It's a simpler, shorter process. There are, with our office, you don't pay attorney's fees, but hypothetically, if you didn't qualify, made a little too much money to qualify for our services, then you're still dealing with attorney's fees that are much less expensive with the summary administration than it would be with a formal.
That's good.
You've got, let's see, and there's no cost for publishing notice to creditors. All those costs add up. And so if you can use summary administration avenue, then it's quick and inexpensive.
No, that's great. I do think too, Ryan, just hitting on that personal representative aspect too, because when someone passes in probate court, having that personal representative is someone really kind of standing in the shoes of the deceased to make sure that the property is distributed. If there's a will in terms of a valid will, or if not, that the property is being distributed as required under the law. But, that can take time. There could be an accounting that needs to be done, a verification that all the property has been distributed as needed through the personal representative. And so you're right. A lot of what we see and we hope to do when you're looking to clear a title is move it through the summary proceedings if possible. But if not, it doesn't mean that a formal is going to take, months upon months. There's ways to get things organized and to move those cases forward too, if that's what you need to do. But it's good.
Yeah. And I should have elaborated a little bit on personal representative, and you said it, that they stand in the shoes of the deceased. They determine what the liabilities are, who the beneficiaries are. When the judge orders, okay, this property is going to go to this person, this property is going to go to this person, the personal representative is the one who steps in and maybe executes a deed. Or physically moves that grand piano or whatever it may be to the beneficiary, and they are the party that's sort of the middleman between the court and the beneficiaries. Versus in a summary administration, it's usually not, there's typically not enough assets and property. There's no grand pianos typically sitting around that you would have to worry about distributing. It's typically a home and maybe a vehicle and some personal property inside the home.
No, that's good. I appreciate you saying that too, because that is another issue regarding probate proceedings. I would ask, well, what if the person who passed away didn't really own any, what we would call real property, which we would consider land or homes, they didn't have any of that. What do we do in that instance?
There's a third process called disposition of personal property without administration. And what that is simply it's essentially a simplified procedure, probably even more simplified than a summary administration, because you don't even need an administration of property. You're essentially showing the judge that we have personal property in the nature of, a four-wheeler, a boat, something of that nature. If the person who died doesn't own real property and we're just dealing with tangible property, as long as it's within, there's a threshold. I'm not sure if you know the exact threshold, Gio, but I believe there's a threshold in value of the personal
to be able to claim. Sure. For the to be able to bring it through the personal property without administration for it. Yeah.
Yeah, I think I made a note on this. It's the property of the state's got to be not worth more than the reasonable funeral expenses and reasonable medical expenses for 60 days prior to the decedent's death. And so you would look at those expenses and compare. And as long as you're beneath that threshold, then you would be able to file that expedited proceeding where you own the property when you're done. You've got a court order and you're safe.
No, that's good. And for us too, over at Legal Service, we don't see this as much because a lot of what we've handled primarily deals with a lot of probate through for homes and homesteads, trying to get people in a safe, clean home environment. But one of the things we do see that too is we do see a lot of contention regarding claims from creditors. What is exempt? What's not exempt? I know you kind of touched upon this too, but I do think it's helpful to kind of clarify. What do you think would be exempt property too? And how do creditors come after that? And when are they entitled or not?
Okay, so one thing that the court determines is whether the property of the estate is exempt or not. And some people may be surprised at the value of the property that is exempt. It includes, I'll just go over the three main exempt property examples that we see. Household furniture, furnishings, and appliances up to $20,000.
Yeah.
I don't think I have $20,000 worth of furnishings in my house. I doubt that most people do. So most of all that typically is going to be covered. Not one motor vehicle, but two motor vehicles are covered as long as they were regularly used by the deceased or their immediate family. And then the big one is homestead property. And that's typically what I think you and I see is folks that come in and there's really only one property, and it's a $60,000 or $80,000 or $15,000 homestead property, and that's typically the client's primary concern. But those are all exempt properties. So when you're looking at back when we were talking before about simplified procedures and simplified administrations and whether you could quickly gain valid title to your home, this is one of those scenarios.
That's good. No, I think it's important too, because when you can see those and claim some of those exemptions, as you mentioned before, I don't think people understand, well, how wide that might be. And then that really helps, especially that homestead exemption is key. I mean, what we see, but beyond just what property might be exempt, just in general, for probate, before we get back to our title issues, what are just the types of properties that you believe you often see that can be probated or should be probated that we see often?
Well, you have real properties, number one. Yeah. You have personal property that includes a mobile home or a vehicle. Mobile homes, people think of as homes, but they're legally considered to be personal property. And that's why when you change the title on a mobile home, you go through the Florida DMV or the Florida Department of Highway Safety and Motor Vehicles to effectuate that. Financial assets, intangible property. So you have, if the deceased had bonds, stocks, even if it's a small amount, those have to be included. And so what we try to have our clients do is really do as much homework as they can to tell us what assets and liabilities may exist. But that's what the court is looking at financial accounts, real property, personal property. Some of that may be exempt. Maybe all of it's exempt. Typically not financial accounts, unless it's under the threshold. But, those are the three most common types of property that, frankly, you have to go through probate to make that change.
Right. That's right. You may not have to probate your dog, but you need to probably deal with the doghouse they're in.
The dog, I think, you probably
the truck that you take them with. Yeah, the truck you take them in, and at least two of them possibly, and then the house that they live in. And so that's what's important to keep in mind, especially if there is no will in play that says what to do with all. I want to double back, and on the, I believe the 15th, we're going to have a series kind of on rental purchase agreements. And that's more often than not where we see a lot of mobile home issues. But Ryan's right. Unless a mobile home is attached to the land and owned by the same individuals, and it's been declared as real property, and you'll see a black RP real property sticker on it, mobile home will be considered personal property, similar to an actual vehicle that you drive on the road. So people don't sometimes think about that, but you'll have to go through the Department of Highway Safety and Motor Vehicles to deal with the title transfer for that. And so we're going to talk about some of those pitfalls regarding rental purchase agreements on the 15th, even more in depth. But one of the things to keep in mind is, a mobile home, even though it is a home, it's in the name, you would think it should be considered real property. It may not necessarily be the case, and more often than not, it isn't what we see. So if you are a victim of hurricane damage, you want to make sure to go through the Department of Highway Safety and Motor Vehicles to access either the title if it's in your name, or have to go through probate proceedings then to have that expedited in someone else's name. So it's key. Now, in order to bring probate proceedings, so one of the things I wanted to ask Ryan are just what is if you could kind of give us a summary of some of the top documents or things you would need to bring to the court, to the clerk of court to file this claim.
Number one is going to be the death certificate. You have to have that regardless. You can obtain that through the Bureau of, help me out here, Gio, Bureau of something statistics.
Vital statistics, yeah.
Bureau of Vital Statistics.
Yeah.
You can Google that. You can submit an online application. They will mail you the death certificate, or you can go pick it up in your local county. And I would prefer clients to have that up front. It just, if you're trying to get your ducks in a row, that's pretty easy. It's not very expensive. I think it's $35, somewhere in that range. to get a copy of the death certificate. And I would say if you're going to get one, go ahead and get two, because typically you're required to submit the actual certified stamped document to the court, and
That's right.
Physically, so you'd have to mail it. So I usually tell people to get two copies and give me one that I'll mail to the judge. I'll scan it for my file, but that's number one. Obviously, if there's a will, you need that. And sometimes people don't know whether there's a will or not. There is a procedure with most banks where you can ask, you can inform them of your status as a beneficiary or as a lineal descendant spouse of the deceased, and ask them for whatever they have, whether there's any money in the account, whether in that person's account, whether that person has a safety deposit box that could potentially have a will in it. Things that people don't always tell their heirs, that they may say I have a will, but the heirs may not know where the will is. And I would say safety deposit box is probably the number one place to look. So you would look towards whatever bank they use and contact them and ask them what kind of form I need to submit to see if there is a will in a safety deposit box. If you have the will, then great. You would submit that to your attorney or to the court if you attempted to file a probate on your own. But yeah.
Good. No, that's good. I think that's important too. And, a lot, like you said, sometimes the lines of communications aren't open between couples and trying to find all this information. So it's nice.
I forgot about a couple things, Gia. I'm sorry.
Sure.
Funeral bills. Funeral bills pretty big. The court typically wants to know that the funeral was paid for. And so I would say anytime you can get that, and any expenses that are associated with that, a copy of the deed to the property. It's good to, most of my clients never know that they could go to the property appraiser's website and look up the property by typing in the address, and then they could actually see the deed that was filed in 93 or 2000 or whenever it was filed. Most of those are on file. Those are documents that you could have in order before you went to speak with an attorney, or that you would really need before you filed a probate petition.
That's right. On a rare chance, sometimes we have had cases where the deed's not been recorded with the county, and you just might have an old copy there of an old deed that's been in the family for you. It's still important to have that and to keep a copy of that too. But I can't stress enough. Yeah, especially in those instances, because that is the only proof you might have. I can't stress enough what Ryan said about multiple copies of the death certificate, though. A lot of what you might need, trying to get funds from Social Security from a spouse who is a recipient, or as well as creditors or banks might require. So multiple copies are important, and especially if you need to know you're going to have to, like you said, provide that certified copy to the clerk of courts when you file the claim.
And when you say that, you're talking about that. Well, one of your points is that folks shouldn't just obtain one and make copies of it, because they may need a certified, sealed document that needs to be sent to the insurance company or the mortgage company. Either way, it's good to have at least two, I would say.
That's right. At bare minimum, yes. I know Social Security as well, and insurance companies too. And so having dealt with this for clients, and even in my own personal family matters, that's one of the biggest things we always try to do, is make sure in advance, once a death certificate is available, to get a lot of those copies of those certified in advance, so you have those ready to deal with a lot of the claims that might come. Especially because it is hard after the passing of someone to start thinking about all the things you need to do. So I want to provide that advice out there as you're dealing with probate and such too.
Well, I think I'm going to take the reins and start asking you a few questions, Gio. That's all right.
Sure. That's totally fine. Yeah.
Let me go with what are some ways to avoid the pitfalls of unclear home ownership?
Yeah, no, I think it's important to think that there are some steps you can take in advance instead of just dealing with an issue of title through probate proceedings. As you brought up, Ryan, a probate normally comes through a deceased individual's properties. So, but while an individual is living and they have clear title in their name, or if you're in a probate proceeding and you want to be the sole or a main recipient, sometimes it's best to think of how to maybe put your best foot forward in making sure that you're able to have the title in such a manner that your family and you and your family can have all the benefits that could be conferred from having a clear title. And so one of the simplest ways is just, if you are a married couple, go ahead and have the title to the property in both of your names if you both agree to have it as a joint asset. And that way,
and that's pretty simple, right? That's you could, if you qualify, you come to our office and we could draft a deed that from yourself to yourself and your wife, or from your wife to yourself and your wife, to ensure that you both have property or both have title.
That's it. That's straightforward. So that doesn't require a major court proceeding or anything along those lines. It'd be as if you're
go ahead. Yeah. Sorry, George. You could also include in there a survivability provision where you have rights to survivorship, where there's really no need for a probate as long as you have it drafted that way.
That's right. So the spouse would be able to keep all the benefits as a surviving spouse after the other spouse had deceased. And so to be able to retain possession of that too. And so that's very helpful because then it sets the other spouse on the best foot forward. And then that individual, if they're the surviving spouse and they still have the title in their name, they could still confer that title and draft a new title into their whoever they would desire to have and retain the property after they have passed too as well. So it's one helpful way, thinking ahead too. A second way though that we think about it too is just making sure to record all the deeds that you have, with the department, the official records department at your county clerk's office. As I mentioned a couple of minutes ago, we've had cases where we've seen some deeds come out and, sometimes they almost look like ancient Latin manuscripts and, the staple might have rusted off of them. And we just think, oh man, you'll look through the clerk of court's website or you'll check the official records for that county and see, okay, there actually isn't a current title listed there. And so you want to have that deed recorded as best as possible. And sometimes if it's something that needs to be updated, then as Ryan mentioned before, it might be a matter that we could quickly help to make sure that that deed is updated and accurate if the individual who has that deed in their name is still alive and living.
And when you say recorded, that's just simply going down to the court or to the courthouse and paying a small fee and asking the clerk to file it in the record.
It's perfect. That's right. There's an official public record of all official documents in the county, and especially for land and homes. And they want to make sure, the counties want to make sure that they have an official record of what's happened with property, with real property, land or homes. And so you'll see often, of course, mortgages are recorded and other financial agreements, but specifically deeds to the property and the titles thereof. It's not a major ordeal, but it will be a small fee, not very expensive. But that's, you can get it down and it'll be certified into the official record. And that way, both yourself will know, but you'll have clear legal title to that property if you are listed there and it's been recorded first. So, yeah. The other one, though, I want to mention too, and we'll touch about this when we do our rental purchase agreements, is making sure that you're keeping your taxes up to date. Fortunately, you might want to make certain that the tax collector's office does have a current listing of you as the record title owner, and also make sure that all the taxes listed there on the tax roll, meaning the official publication from the tax collector's office of what taxes are owed for each year, that it reflects you as the accurate title owner if you own the home, and that all taxes have been paid. Because sometimes if they've not been paid, then it does allow a certificate for those taxes to be that are owed to be purchased by other individuals. They're called tax certificates. And unfortunately, far too often, individuals could lose their homes, and if they don't pay that tax certificate off at a certain time, then a home can go up for a tax deed sale at an auction. And so we'd hate to see that happen to you. And so it's always important to just make certain that you're staying on top of those property taxes in time.
Let me say something real quick, Gio, about that. Taxes, I'd say one easy step that folks could do to get a picture of what's going on with the property is, number one, look it up on the property appraiser's website. All you have to do is put the address in. It'll show you the current owner. Whether legal title is perfect on that is maybe debatable, but you can see what the property appraiser considers as the title holder. And from there, you can go to the tax appraisers or to the tax collector's website, and you can see whether there's any back taxes, whether there's any movement, or we'll say aggression towards, we'll say, that property. It'll be listed on the website, and that'll give folks an idea of what scenario they're in, or whether they're in an emergency scenario where the county is taking action to possibly foreclose on the property.
No, you're right. Ryan, that's important too, because I think at that point, even if it is something that's happening where the county is looking for a tax deed sale or such on the property, there's still time to redeem that property before the tax deed sale and to verify what to do. So I'm saying that's one of the reasons why it's helpful to kind of plan ahead, Real quick, I just wanted to say, we have talked about this before, but sometimes preparing a will to make sure that the transfer of your property goes in accordance with what you desire and your wishes. Florida does have what we call the intestate statute, and that's set up. An intestate statute determines how your real property will be distributed to your lineal heirs too, and family members upon passing. But if you desire to go to a specific person or a specific family member in a specific way, it's helpful to go ahead and meet with legal counsel and verify what that might be too. And so I know in Tallahassee, we have the advanced directive clinics to help a lot of individuals with that through probate. Our other, as Ryan brought up before too, even in Bay County and surrounding counties, we do have the opportunity to provide assistance sometimes with some of those probate matters, including trying to make sure things are prepared beforehand too. The last one I just want to say is any schemes that you might have to be aware of regarding the property, to sign it over to someone else who wants to live in it. Really make certain if someone's asking you to sign a document regarding the property and your rights on that property, the biggest thing I would recommend is just have it double check it first. There's no emergency sometimes, too important, no issues so important that you wouldn't take time to make sure that what you're signing over, that you clearly understand it, and make sure that you have all of the required witnesses there with you and a notary there when you do sign it too, so that it is legal. But far too often we see individuals have signed over properties through what they call a quick claim deed, quickly to confer that property to someone else without making certain that they fully understand what they're doing. All right. And so we want to make sure that if that's you, just take the time to read carefully and know what you're doing before you sign.
Would you say that it makes it more convenient for my beneficiaries, the heirs of my estate, if I draft a will before I die?
Oh, I do think so. Absolutely. I think the reason being is because then it allows the court to understand what your wishes are with the property, and it can confirm exactly how the property should be distributed. It also allows your family to know, because the intestate statute can be difficult. It's difficult for me to say the word intestate now, much less to determine all the lineal descendants from the family, everyone who gets a slice of that pie. And so they may not know. It could lead to squabbling among the family that you don't want. And so sometimes having it clearly listed beforehand provides a sense of peace in passing, because death is tumultuous. And so it's nice to be able to have things prepared beforehand if you have the opportunity, and not leave the family in the dark.
And you can even put in provisions that penalize your heirs if they want to challenge your will and everything. You anticipate your will and your probate going smoothly because you carefully drafted your will. But there's always this concern that maybe one of your heirs may stir up some trouble, or maybe two of your heirs don't agree or get along. And there's also protections you can put in there that says, you will be penalized to a certain degree if you challenge what I've written in this will, as opposed to when there's no will, you could litigate that for 2 years, theoretically. And that's certainly not what the deceased wanted to happen before they died. So I think that's one thing that's worth mentioning.
Yeah, absolutely. As you said, and it brings down the cost sometimes beforehand for attorneys trying to battle it out for each of the family members, and other things we've seen all too often, and kind of can create the flow of the case. But Ryan, I see here we're kind of running short on our time too that we have.
Okay. Yep.
I didn't know if we wanted to open up for questions real quick, if that's all right, if there was anyone or not, or Rachel.
It doesn't look like we have any questions at this time, but we can go ahead and wrap this up. That was great information, guys. Thank you so much. As always, this video provides legal information and should not be considered legal advice. This video does not create an attorney-client relationship or substitute for legal advice that you've been given. You may have defenses we have not discussed here, so always seek an attorney or legal help. And for more information, visit lsnf.org. And thank you for joining us.
That's right. Please come back on the 15th. Yep. We really appreciate it. And Ryan and I will be here to answer more of your property questions and help you be prepared for those disasters that have unfortunately hit Florida all too often.
All right. Thank you, guys.
Yep. Thank you. Thanks, guys.
Thank you, Ryan. Thank you, Rachel.